The conclusion contained in Exhibit O doesn't support drawing of a negative inference on the part of Mr. Zuma, and indeed Mr. Dlamini, who also drove at the same speed. The court can return to the four instances that the state indicated it was relying on as instance of negligence in response to a request for further particulars in terms of Section 887. In doing so, the question is whether evidence has shown that to be the case. There is no evidence that indicates that he failed to keep a proper lookout. I accept the defense argument that none of the evidence presented established that there was anything that a reasonable man in the position of the accused on that night would have foreseen. It is so that all the evidence shows that there was unforeseeable puddle of water on a national highway and that a reasonable driver would not have been able to see it in the circumstances and inadequately take any action to avoid it. The accused was driving a roadworthy car, and the issue in regard to the condition of it is neither here nor there, as was belatedly argued by the prosecution. It has been established independently that the tires were within the legal limit of 5 centimeters. He was driving at approximately 90 to 100 kilometers. The other road users made the same determination that that same speed was reasonable in the given circumstances. There is no evidence to suggest that the accused firstly should have foreseen the presence of a puddle. The other two drivers didn't see the puddle of water, but we know that when the passengers alighted the minibus after the collision, the water was angled high and covered their shoes. And secondly, there is no evidence to indicate what step he should have taken to guard against aquaplaning. And in particular, no evidence is available to the court to find that the speed to which it might have been set a reasonable driver would have had to reduce his speed in order to avoid what eventually happened. It is therefore found that the state failed to prove the case against the accused beyond reasonable. The version of the accused is found to be reasonably possible true. The accused is found not guilty both in the main and the alternative count.